Welcome to the Real Estate Syndication Show. Whether you are a seasoned investor or building a new real estate business, this is the show for you. Whitney Sewell talks to top experts in the business. Our goal is to help you master real estate syndication. And now your host, Whitney Sewell.
This is your daily real estate syndication show. I'm your host, Whitney Sewell. Today our guest is Gene Trowbridge. Thanks for being on the show again, Gene.
You're welcome. Thanks for having me, Whitney.
Yes, I'm honored to have you back again. And as the listeners know, if you've listened the last couple of days, Gene has been gracious enough to walk us through these documents that whether you're in the business as an operator or whether you're in the business as a limited partner, passive investor, you have to understand these documents. There's some specific things that are so important that you know, and it can be very complicated, and you need someone like Gene that's an expert that can help you help explain what some of this means, and so you know things you need to focus on, or maybe you need to ask the operator about, or different things. But grateful for you as the listener, just grateful that you're here with us again today. And today we're going to talk about the subscription agreement. And Gene's going to help us to go through that, and just that and the relationship between that and the other documents we've talked about, and some other questions. So, Gene, and let me back up a little about Gene. You probably heard this yesterday, but I always like to highlight he's the founding partner of Trowbridge Law Group LLP. He's representing over 400 clients, and also I just like everybody to know that Gene was a former syndicator. He's been on this side of the business. He understands this business inside and out. He's a CCIM senior instructor. And has a book that should be on everybody's shelf in this business called It's a Whole New Business. You can also find that book on my website. If you go to our recommendations page, you can find Gene's book and a link to it right there. So thanks again, Gene, for your time. Let's dive right in, Gene.
Okay, well, that's great, Whitney. So let me go back to finding the book on your website. So is there a link to the free PDF copy?
No, I should do that. I didn't know there was a free PDF copy.
Oh, never mind. I misspoke. Sorry. So I'll send you one.
Okay. Yeah.
I'll send you a link, and then you can do that. And I'd be happy to have everyone have one of those. That's just fine. Well, let's see. We started this journey. This is becoming a habit, Whitney, you and me. We started this journey talking about something that we called the PPM. Well, the PPM is really, the PPM is really a name, acronym for the Private Placement Memorandum, and it really includes a number of documents. When we talked about the PPM, we were looking at something that's really the disclosure document, the story of the offering. And we try to write it, when we draft these for our clients, we try to write it in as much plain English as we can. So they read that. We hope that that's the first document that the client reads or their investors. And so that's the disclosure document. And then that has some exhibits. There's an exhibit that shows, we always put the organizational document showing that the company is actually formed in a particular state, and give the investors that information. Then Exhibit 2, which we talked about yesterday, was the operating agreement. And the operating agreement is the rules on how the company's going to run and how we're going to try to make this story come alive and happen. And then there's Exhibit 3. And Exhibit 3 is the subscription booklet, which we're going to talk about today. Basically, a contract, an offer, and some background information from the investor to the sponsor to see if the investor can take part in the opportunity that the sponsor has put together. And then in our documents, we have Exhibit 4, which is the business plan, the investment summary, the property package, whatever it is, it's all about the property. Some offerings we have more exhibits. Some of the offerings we're doing today are tenant in common deals, so we also have the tenant in common agreements. But basically it's the 4. So here's the subscription agreement. The subscription agreement is really the only document the investor signs now in the way that this is being done. We don't have the investor sign the operating agreement. We have the investor just sign the subscription booklet. So it's relatively simple. You see the table of contents is relatively short. I've highlighted a lot of things, but it's not all that much. There's 3 parts: the instructions to someone who wants to subscribe, and then number 2, the subscription agreement itself, and number 3, the offering questionnaire. And the reason for all those parts. So I guess if an investor wants to invest, they're going to read all the documents, they're going to get this, and then we tell them how to complete the book. You need to do the subscription agreement and then the offering questionnaire.
Gene,
So
I was gonna tell you too that we're not under a time crunch today, so I want you to have the time to explain this, in the time that you need. And then I wanted to remind the listeners as well that this will be on YouTube. Gene is sharing his screen, and you can see the document as he's going through it. He's highlighted specific things that he's talking about, just so you know if there's something that you want to, if you're listening to it right now, going down the road or wherever you may be, and there's something you want to see, you can go back to that on YouTube and actually see exactly what he's talking about.
All right, so we're talking about just instructions on how to do this, and we're down to the subscription agreement. Now, the subscription agreement says, if you read right under Roman numeral 2, the undersigned hereby elects to purchase Class A units. That's generally what the investors buy of the offering. So here's the investor's offer, if you would, to me, if this were my offering, to invest. And then we talk about the purchase of units, and we rehash. Now, most of this information has already been covered because it's in the PPM, it's in the operating agreement, but here it is again, because this is what we're going to sign. So the person who's filling this out is going to tender a check in the amount of X, representing a total purchase of X number of units. And in this offering, the units are $10,000 per unit. And this offering has a minimum investment of $150,000. Now, this says a check. Not every subscription asks for a check. Some subscription agreements don't want any checks at all. They want you to wire the money. Okay. And so you have to read this and see, how does the sponsor actually want your money? Sometimes a check is fine, and then you'll find out later in the document that it says, if you want wiring instructions, we will give you wiring instructions. And then it goes on to say that I understand my admission to the company is contingent. What? Contingent upon the acceptance by the company. For those sponsors who are out there, you have the total right to say yes or no. You don't have to take an investor if you find from the offering questionnaire that you don't think the investor is suitable for this investment. You can turn them down. That's your right, and it's really your obligation to the other members and to this member if you don't think this is the right person. It's 7 o'clock here. My voice is just waking up, Whitney, so excuse me. And then it comes down, there's a term in here called breaking impounds. If you remember, this offering had a $5 million minimum and a $15 million maximum. So until the sponsor raises $5 million, all of your money will be deposited in a bank account owned by the company, and then it will be used for the purposes described, which will not occur until we break impound. So the money is just going to be sitting in there in the account, and there might be some interest earned, but today that interest is so insignificant that we don't deal with it. And when the $5 million comes, Technically, the term is that you break impounds, and the sponsor can go out and use the money. It's generally used and stated to be used in the PPM and the operating agreement to buy the first property. Remember, this document we've talked about is a blind pool. If this were a specific offering, the amount needed to break impounds would be what you need to buy the property. And then probably we continue to raise money to find money for the CapEx expenditures in the future, if you were going to fund those with cash or fees or anything we're going to do later. Usually there's a minimum and a maximum. So the money just sits in there until you break impounds. And sometimes, gosh, this is done so many different ways. Sometimes the sponsor has gone to a bank or someone who will do this for them and set up a checking account, which is fine, but set up a savings account and has given, it's not really an escrow account like you would think there'd be an escrow account at the escrow company to buy the property, but I'm going to call it an escrow account. And so all the money goes into the escrow account and stays there. And the sponsor has a relationship, a contract with the bank that says, we're depositing all this money, and when it breaks impounds, you transfer the money to our checking account. If it doesn't break impounds, you send everyone the money back and any interest they might have earned on their deposit. That's a little more complicated, but I've seen that on certain offerings. And how would I know what's happening to my money? I got to read the darn document. And then when we accept the subscription agreement and the membership, we'll send you a receipt, and I'll show you what that's going to look like in a minute. One of the things you're doing here in the new way that documents are being drafted is this is what the investor is going to sign. So the investor here agrees to accept the company agreement. You know, I accept every provision of the company agreement because we're not having the investor sign the company agreement. Representations and warranties, and we kind of go through stuff. Some of the stuff we've already gone through. At least we've explained in both the PPM and the operating agreement who's suitable for this investment. Are we taking accredited investors? And we're asking the investor to say if they meet one of these suitability standards. And we all pretty much know what those are: $1 million of net worth, 200,000 of income, or 3 if you're married. And then there are a number of other definitions of accredited investor. Depending upon who the sponsor is, we may or may not include in the subscription agreement. But this is a pretty thorough listing of if you are accredited. Now we're going to go into suitability. Just because you're accredited doesn't mean you are suitable. But we're asking you, after you've read everything, is your investment in other things that are not readily marketable, not liquid, is it disproportionate to your net worth? Well, I'm going to ask you another question about that, but this is one of the representations I want you to make, and then I want you to tell me that everything you do in the subscription agreement and all the information you give me is the truth. That's important. And then we go through the section of risks. Now, the section of risks is going to be quite a bit regurgitation of the risks that are already explained in the private placement memorandum. Risks really aren't in the operating agreement. They're in the disclosure document. And so it says, I have evaluated the risks of investing in the company, and attest. That's like sitting on the witness stand and saying, I attest to the truth. I testify that all the following statements are true. Hey, I understand that the private placement memorandum is important, and oh my God, I've actually read it. And I've read the company agreement, and I've read this document, and I've read all other documents. And everything I've said is true, but I've actually understood it. I understand that the investment involves substantial risks, and I've taken full cognizance and understanding of all the risks, and I've read the risk factor section in the offering materials. And then we come down here, the next one is, darn it, the next one is about the offer to sell was directly communicated to me in a manner such that I was able to ask questions and receive answers. Okay. Now, depending upon if it's a 506B or a 506C, we have to have some sort of a comment in there about solicitation. If it's a 506C, we really don't care too much. Actually, this offering is a C, and I left this in there. I just want them to say, how they got introduced to the offering based on what I know the sponsor is going to do. The sponsor is not going to put ads in the newspapers, magazines, radio, or television. And I want the people to say, yes, I didn't get information from there. If it's a 506B where there's no advertising at all, this paragraph's a little different. Hey, I was not solicited. I had the dreaded pre-existing substantive relationship with the sponsor, and it was directed, the offering was communicated directly to me. Okay. These units are being acquired from my own account. Okay, we have suitability standards. Whitney, we can't have you buying, 100 of these units and then selling it to your friends. In this particular offering, all of our investors have to be accredited because it's a 506C. So we have to be careful of that. And on top of it, Regulation D has a rule that there cannot be a resale of units within the first 12 months of someone acquiring them. And that rule is just to keep what I just said from happening. We're not having someone buy some and resell. Now, there are all sorts of things that could happen in the first year. Someone could die, they could get divorced, and we can work through that. But a sale of the units is going to cause some trouble because it could violate our exemption. So the company wants to put a stop to that. And that's what this disclaimer is. Here it is, and we even go farther, that the units will not be resold unless the units are subsequently registered with the Securities Act, or the person who wants to sell the units gets an opinion letter from another attorney that this will not violate our exemption. Now, all that's fine. But yesterday we went through Article 11 in the operating agreement, Whitney, and we talked about liquidity. Voluntary liquidity, liquidity through an act of law. And we talked about all the ways that units can be transferred. That's one of the 4 questions an investor should ask is there liquidity in case I need to get my money out? And a well-drafted document has liquidity provisions, and as long as you follow the liquidity provisions in the operating agreement, this representation won't cause you any trouble. And then the last one is I'm able to bear the economic risk in case the investment becomes completely worthless. Now, why would anyone invest if they see that language? I don't know, but that's what we have to say. When I was doing storage units, one of the very first things in my risk section is, if all 800 tenants move out today, Whitney, we're not going to be able to make the mortgage payment, and you're going to lose all your money. And I always tell that story because face to face with investors, I like to say that, because if an investor laughs at that, meaning, well, not all 800 people are going to move out, blah, 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 I think I've got an investor who's got some experience.
Right.
If I say that to someone and their face tightens up and their body language goes like this, well, let's not take them as an investor. Let's not take them. They're not ready to do this. Then we go into other considerations, which are still kind of more like risk factors. Hey, this company has no operating history. The manager might, but this company doesn't. There's restrictions on liquidity. The financial projections are only estimates. We're not guaranteeing anything. Tax effects of distribution are up to the individual investor. No agency has made any determination on whether this is a good offering or the books are written well. Conflicts of interest. Hey, I'm Gene Trowbridge. I've got 16 storage facilities that I'm running right now. There's conflicts. I can only devote my time so much to any one unit. If there's a need for a member advance or a member loan, and if I have any money, I can give it to that unit, but not this unit. There's all sorts of conflicts. And then if you're a real estate broker, we've written conflicts in the PPM that says, as a broker, representing other clients and representing this property, I'm going to have conflicts. And we need to explain all that. And then the manager has retained legal counsel. The legal counsel is just for the company. I do not represent an investor. Generally, I won't talk to an investor unless the sponsor's on the phone call with me. My fee agreement is with the sponsor. Okay. I won't review other people's documents for investors. I think that's a conflict for me. So we need to understand that. The manager may receive compensation. Okay, where's that? That's in both the operating agreement and the PPM. I love this one. I understand that the offering materials supersede any other facts or assumptions. Well, what's it going to take? 3, 4, 5 weeks to get this all ready to take to the market? And you're doing your due diligence, you're working with the lender, all sorts of things are going, and you're talking to potential investors. Who knows what happened that you represented in June that isn't the same that you're representing now on the 1st of September. Okay. Who knows what you said to who? So this is the only document that counts for your protection and for the investor's protection. Everything that's in writing in the PPM is, like the blocks of the 10 Commandments, man. This is it. Don't bring any other information in. If it's not in the PPM, it never was said. And for the sponsor, it's very, very important. I put it in writing. I said it. I never promised to send you any money. If you think I said I promised, let's look at the offering documents, which says we project, we may. Okay? Totally different words. And then you say that you actually can sign this. That's important if we're investing for an entity. Let's say an LLC wants to invest here, or a family office. How do you know that the person who's signing the document can actually do that? I understand that acceptance and execution constitute acceptance and execution of the company agreement. Remember, this is where we're signing. This is an exhibit. And instead of doing the company agreement, we're going to sign here. And then we allow electronic signatures. This is a big change in the industry, and I'm not going to go through this, But many times our sponsors are using a back office company to help process the offering. And we take this document and we give it to them, and they electronically modify it. And so then when people go to their website and sign, they don't do anything manually.
Just like
So
using a portal, right? Or DocuSign or something like that.
Right. A lot of people have portals. A lot of our companies, in fact, if we'd had portals, when I was making the decision to go to law school and stop syndicating, I probably would not have done this. One year I sent out 1,676 K1s. I spent 3 months licking envelopes and putting stamps on, and there were no portals. There was no IMS or Redwood or whatever there are, but there are now. And so that makes a difference. I think a portal is a little overkill on your first deal with 20 investors, but Whitney, you do 4 or 5 deals, you've got 150 investors. Now we're talking about some mechanics. And you can staff it yourself, which is what I did, or you can go outside and have someone else staff it. And that's pretty prevalent today. So then we have a question here. One of the definitions of an accredited investor is that you're smart. And one of the ways you demonstrate the fact that you're smart is that you use a registered investment advisor to make your decisions for you. You might be the person who's, typically this is an older person who's subject to a trust, and all their money comes out of the trust, and the trust is being governed by the trustee and a professional advisor. And so if you're going to use a professional advisor as an investor, we want to know who that is. We want to, and the sponsor is not a registered investment advisor. This is a career, this is a bonded, this is a licensed person. And we want to know who that is, because they're the one who's making the decision for the investor and making the determination that this is suitable. So we have that information. And then it says, after you execute this subscription agreement and send us the money, the company will make a decision if they want to accept you. Now we're gathering information. We need information on who wants to purchase. Pretty self-explanatory, but this is the one that causes everyone so much problem. How are we going to hold title? I will tell you right now, Whitney, if you're the sponsor, this is not your responsibility. You can't know how the person should hold title. You know about them, but you don't know anything about what their estate planning is. You don't know anything like that. And I get many, many, many calls. How should this client take title? And my answer is they should call their CPA, their attorney, or their trust attorney. Do not give them advice on how they should take title. And you need this, right? You need this correctly so that the CPA can deal with the K1s, the tax returns, and the K1s correctly. Now there are a million ways you can take title, okay? But here's a way that if you're doing this electronically, you can check a box, and that helps. And then underneath this, it says that there are several states, I think there's 7 states that have community property laws. So I'm in one right now, California. If I sit with you, Whitney, and I want to write a check, fill out a subscription agreement to buy units in this fund, you have to be alerted to the fact that when I write this check and I tell you I want to take title myself, you may have a problem with my wife down the line, because did she approve me going into the company checking account and writing a $150,000 check out of savings or whatever and putting the title in my name. So when your investor is from one of these states and the choice is they want to take title individually, you need to ask them if they're married. Now, I could have been divorced in the past, and I could have my own separate property from that other marriage. Now I'm married, but I couldn't take my money that's mine and take title as an individual, as a sole and separate property. That's fine. But you need to protect yourself. This is what I say to everyone. If you're going to have an investor from one of these states that's going to take title individually, ask them if they're married, and if they're married, provide them with a community property waiver. And basically all it says is the spouse who's not signing and not wanting title in their name says, I know what's happening here. I understand. I'm not making any claim. And then you sign it. Okay. Now, a year from later, something goes wrong. The spouse speaks up and says, hey, I want my money back. This never should have happened. You're covered, because this is going to cause the company problems. I'm not worried about the husband and wife arguing. I'm worried about some attorney calling us and saying, we want $150,000 back from the bank account because you never should have taken that investment. Okay. It's a lot more complicated than that when you have unions out there that aren't actually married, and who's investing whose money. So it's something that you have to identify and ask questions. In fact, just as an aside, one of the things that they're thinking about in the accredited investor definition is expanding the definition of accredited investors to a household where otherwise you would say these people are married, but maybe for some reason they aren't, okay? But they're investing together. If their net worth or their income meets the definition, the 200 or 300, they can invest as accredited investors, even though they don't have the piece of paper that says they're married. I don't know if that's going to happen, but it makes some sense to me, and it would clear up some problems that we have, that sponsors have.
So it kind of it brings in that couple or that person that they're not married, but they are in that household. It's going to bring them into the agreement, or at least the person that's signing is agreeing that they're part of the household.
That would be my recommendation.
Yeah.
That would be my recommendation. In fact, I have a couple sponsors who are married and same-sex marriages, and we go through this. We go through this all the time. They brought their own money to the relationship. Whose money is being invested? Is it money that was earned after the marriage or before the marriage? And the two groups I'm talking about are in Texas, which is a community property state. So we've got that problem that we have to talk about. And then if it's going to be an entity, I have this checklist of things. Hey, if you say you're going to invest in a partnership, a family partnership, well, I need to see the document that gives you the authority to sign and invest the money for the partnership. Once again, to protect the company. I don't want someone coming 6 months later and say, we didn't approve this investment. And I learned that a long time ago when I was selling real estate. I sat down in an office with the person. He signed the listing agreement. I brought a full price offer in for this office building. And we found out that he hadn't had the authority to sign the listing agreement and to agree to pay me a commission. Totally different if you're selling houses. You're sitting at the kitchen table. The husband and wife, chances are they have the authority. But in the world of LLCs and corporations and everything, I would always advise someone to check, where's the authority coming from? And yes, you have to ask them, okay? That shouldn't insult them. They've been asked before, ask them. And so I go through a list of things that I'd like the investor to provide. And then we sign that. That's all the subscription. Now we're in the offering questionnaire and I'm gathering information. Okay. Where do you live? Well, that's important for their tax returns. That's important for the state notices that we send out. Do you have a house or an apartment in any other state? That's kind of important, once again, for tax returns. Where do you pay your income taxes? Here I'm trying to identify your residence, right? Because if you were doing an offering that's only approved in Texas, you'd want to make sure that the person is in Texas, right? So we've got 3 questions for that. What's your age? I can't tell you how many clients of mine don't want to ask their investor what their age is. I think that's extremely important, because if your holding period is 6, 7, 8 years, and you're asking Gene Trowbridge to invest, and Gene might invest with his IRA, don't you need to know if Gene is in a period where, number one, 7 or 8 years is too long, and number 2, Gene, are you taking mandatory distributions? And if all your money from your IRA is going into this fund, where are you going to get your money for your mandatory distribution? Don't come to the company and ask for your money. We can't help you. So I think that's an important question. And then we go through, once again, are you accredited? Here's the definition of accredited. Net worth, income, and if, in fact, you have another definition of accredited, which we listed earlier on, you can write that in there. What are the positions that you've held in the last 10 years? Now, is this intrusive? Okay, so it's intrusive. Let's figure out if the person's suitable for your investment before it gets too late. And you have a lot of investors who invest over and over and over, Whitney, so you don't have to be, this subscription agreement can be modified if you're dealing with nothing but past investors, because you know all this stuff. Okay. And then how do you know? How do you know Trowbridge? How do you know Trowbridge apartment managers? How do you know all these people? Do you or don't you? I don't know. This offering's on Crowd Street, and I bought it from Crowd Street. Okay, write that down. That's okay. It's a 506C offering. You can do that. But if it's 506B, I want to know. Okay. And then we want to know if you're experienced in investing. Very important, I think, for the sponsor to know if this is the first time anyone's ever invested in an LLC that's not liquid. Okay. So we need to talk about it. I might have mentioned this somewhere in some offerings. If the minimum investment is large enough, I'll put in there a question that after you've done your minimum investment, I have some clients who the minimum investment is $500,000. After you've invested your $500,000, how much money do you have? How much liquidity do you have? $4. Okay, don't take that person. So I think that those are some other questions. And this subscription agreement can be modified for the specific offering. And here's some more questions about where the state securities notices, where do you file your income tax or your annual reports if you're an entity, where was the entity formed? That's all important. And then we sign it, and then we go right back up to the beginning. It says, what do you do with this? Okay, complete the booklet, complete the offering questionnaire. Now do what you're supposed to do. And somewhere in here, it should tell you where to send it. You're supposed to send a check. You're supposed to do that. Or there's a separate instruction letter that's a cover letter that goes with it. And that's what I have in this particular document. Where are you going to send it? And where are you going to send the check? So that's the end of our march through the 3 documents. Just quickly, the PPM, the disclosure document told the story. The operating agreement gives you the rules. And the subscription agreement basically says, hey, I've read all this stuff. I'm qualified. I'm suitable. I want to invest. Will you accept my offer? In this case, it's $150,000 minimum. And the sponsor can say yes or no. It isn't on this document because it's a standalone document that I have. Let me do one thing just for a, I guess I don't have it here. Okay, so there's a document that's the receipt. It's called Acknowledgement and Receipt. And that's a standalone document that you would send to the investor when you accept them. You break in pounds, everyone becomes a member. You send them this receipt that tells how many units they bought, how they're taking title, and then you sign that. And that's the receipt they get. Sometimes my clients like to send them a completed subscription book, but they've already received the subscription book. The clients have already seen all the documents. They're just executing this and making an offer. So you really don't need to send them that, but some people like to do a nice fancy final set of documents, but it's kind of up to them.
Like in a book,
all right,
in a fancy way, an operator would send them all the documents.
Mm-hmm. Or today, it's a link to a Dropbox or a link to something where all their documents are. And
Right.
If you're using a portal, the portal will upload the documents and tell the investor where they can find all the documents.
Right. I wanted to ask you about, and you talked about it right there, but that receipt page and anything else that, say, the investor signs and the operator has to sign, just to, is there any kind of specific order that should take place as far as who signs what, when, and just getting that receipt back to the investor and their funds?
Yeah, there's only one signature. The signature on the subscription agreement accompanies the wiring of the cash until, let's say you're going to wire. You're going to require wiring. Until the money is wired into your account and until you receive the subscription agreement executed, you don't have anything. So that would be the two things that should happen pretty much simultaneously. Sometimes it takes a while for the money to get there, as you know, because it comes out of an IRA account or a 401k, but until those two things are received, you really don't have the complete subscription. And so at that time, I would think I would tell the people, we're going to accept you. I've got your money. We explained where your money is going to sit until we break in pounds. And at that time, I'll send you a receipt memorializing your purchase. Because the syndicator has, and we say it in the PPM up front, the syndicator can cancel this offering at any time. Send you your money back. Okay. Prior to breaking in pounds. Just call the deal off. And then after you break in pounds, it's a little harder. The syndicator has the right to say, well, we raised 5, we bought the first property, but because of this virus thing, I don't want to buy any more properties right now. So I'm going to send everyone a pro rata share of their money back. And we'll just own one property. Fine. So you can do that.
Any issues with an investor, say, wiring their funds before they get the signed receipt? Or signed documents from the operator?
I don't think that's a problem because what is that? It's just a deposit.
Right.
It's just a deposit and the deposit goes back. The securities laws deal with something called irrevocably committed. Okay. When the money is irrevocably committed to the offering, you're an investor. Okay, so when is the money irrevocably committed? When it's spent? We say when you break in pounds, it's irrevocably committed. And in addition, when it's spent, it's spent. Now I have this issue in Hawaii where we have to sign, and I got to talk about that, send these state notices in. Hawaii says when the money goes in your bank account, we're going to start the 15-day clock. Well, and I argued with Hawaii. I said, no, the money could sit in there for 30 days before we break impounds. No, that's not acceptable to us. Our rules is that you have their money. Okay, so we need to know what's all that about. The minute I get a subscription from someone, well, backwards. The minute I have complete documents, Whitney, and I send it to you, here's your documents, go forward, we're going to file the Form D. The Form D has to be filed within 15 days of the first money you accept that's irrevocably committed. So we file it right away, so we don't have a problem with that. And then as you get investors and you get their money that's irrevocably committed, you have 15 days to send your notice to the various states where the investor lives. So we typically consider money irrevocably committed on a specific offering when you break impounds and you close. We go to you, we have an Excel spreadsheet we give you, you fill it out. I want the name of the investor, the state, and how much they've invested. And then we look at the list. If you've got investors in Nevada, we send a letter to Nevada. If you've got investors in Oklahoma, we send a letter to Oklahoma. It's all filed online. Our operation manager does all that. We send the letter, a copy of the Form D, and a deposit, because they always charge you for that. And that has to be done 15 days after you take their money, so that if someone complains and they go to the state and they go to the Secretary of State and say, hey, I'm in Texas and I invested in Whitney Sewell's deal, but Whitney's in Virginia, Texas needs to know how to get a hold of Whitney. So the state notice alerts Texas to how they can get a hold of Whitney. So that's the back office stuff we do.
Okay. And one other question I wanted to ask, is there any way to, and maybe we talked about this briefly yesterday, but it's difficult because the documents are so property specific, deal specific, they're structured different ways, all these things that we have to take into account, even different states and things, but like using a portal, I know we've experienced issues like, you got to put the document in and there's lots of things to make that electronic stuff work correctly. And it would be helpful if there was like some kind of like standard portion of it and then a portion that we could alter per deal. Is something like that possible?
I suppose there is, but the question would be, would it be standard and would it already be in the portal and you just go in the portal and modify it? That answer I don't think has happened yet. It's going to come from the attorney,
right,
and go into the portal. Now, I have a couple clients whose staff work on the subscription agreement. And their subscription agreement, I'm going to use the term anal, okay? It's very anal about, down to, if you send us a check in an ACH way, that's where your distributions are going. The distribution has to go back to exactly where the money came from, and we need to know this, and we're going to charge you $50 if you do an IRA account and all this. That's pretty much preloaded. They use IMS. It's pretty much preloaded in the IMS world, but it changes all the time, so it doesn't help. We have to get it standard, and
sure.
Then they want the subscription agreement first. They're always on the subscription agreement. Let's get it uploaded and let's get it ready to go. I will tell you that I think that there are some websites out there that say they will give you a PPM. Some websites say they'll give you a PPM, and what it turns out to be a slide deck. And it's very, very standardized. And it really doesn't tell you much about the deal.
Right. I would still want it created by an attorney or like yourself. Yeah. There's no doubt about it.
But a lot of those places don't. A lot of those places still have you go to an attorney to get the operating agreement.
Yeah.
So what it is, but I think the future is going to change. I think all this is going to change. I think mechanically. I mean, so example, I have a client I've done 119 offerings with him. Okay. You can't tell me some of those things aren't standardized.
Right.
Right. So it's pretty easy. In fact, I helped him recruit an in-house attorney who does everything. All I have to do is review it for the broker-dealer community and the SEC and say, okay, this is fine. But it's taken us about 5 years to get there.
Yeah.
All right, Whitney.
All right, Gene. Well, I'm grateful for your time. I know as a listener, I appreciate you hanging in there. I know we went a lot longer today, but I think it's so worthwhile. I'm thankful that Gene could just take time and go through this document because, like I said, whether you're the operator or whether you're the limited partner, you need to understand so much about this document. And thanks again, Gene, for your time. Tell the listeners again how they can get in touch with you. And I just want to say, too, Gene is a very loyal sponsor of the show, and I'm just grateful for him. And sponsoring the show as well, and it's just a great fit because he is such a name in this industry and has done such an amazing job. But Gene, tell the listeners how they can get in touch with you.
Thanks for those kind words. The website is trowbridgelawgroup.com, and my email address is Gene, Gene, at trowbridgelawgroup.com. Just send me an email. I use my emails like I do a telephone. If it's something that I think deserves a call, I'll give you a call back. Thanks, Whitney.
Thank you for listening to the Real Estate Syndication Show, brought to you by LifeBridge Capital. LifeBridge Capital works with investors nationwide to invest in real estate, while also donating 50% of its profits to assist parents who are committing to adoption. LifeBridge Capital, making a difference, one investor and one child at a time. Connect online at www.lifebridgecapital.com for free material and videos to further your success.